2024 GAR contract changes. Yes, it's that time of year again. I am Dana Sparks, Director of the Real Estate Academy of America and broker of Maximum One Greater Atlanta Realtors, here with the beginning of our series on the 2024 GAR, Georgia Association of Realtors, contract changes. So please stay tuned. This is the first in a series of many to cover the contract changes. Here is Seema to help. And also I invite you to please take one of our continuing education classes on these contract changes. We start teaching them in December, first week in December. And you can go to www. Real Estate Academy of America and sign up. We've got classes, in-person classes and virtual classes all throughout the month of December, and we will carry them on into January. But let's get started, shall we? So I am just going to dive right in. And of course, I always start with what you really want to know the most. What are the changes to the Georgia Association of Realtors Residential Purchase and Sale Agreement, Form F201? So let me just dive in and we shall get started. Not a ton of changes, but some pretty substantial ones, and I think you're going to like them. So there's grammatical changes and syntax changes and capitalization and paragraph numbering. I'm not going to cover those. And as always, the Georgia Association of Realtors Forms Committee, forms that are similar, there are universal changes. So any changes made to the residential purchase and sale agreement have also been made to the land purchase and sale agreement, lot purchase and sale agreement, and new construction purchase and sale agreement. So let's get started. One of the first things they changed is a minor change on paragraph A, the front page, the fill in the blanks where it talks about closing law firm. They also put in parentheses closing attorney. I think that has to do with how agents and our industry refers to the closing attorney as opposed to the closing law firm. They changed it to law firm a couple years ago. They just added attorney. One of the changes that is consistent with the rest of the verbiage in the contract, and this will avoid discrepancies, is also in the fill in the blank paragraph A on the front page regarding earnest money. They removed the check boxes for the specific form of the earnest money. So it used to say earnest money shall be paid by check, ACH, cash, or wire transfer. They've removed all those check boxes, and it now just says earnest money will be paid to the holder in a method of payment acceptable to the holder of immediately available funds. And they had added that verbiage into the corresponding paragraph B last year. So now they just made A that correspond to the fact that the holder, the form of the earnest money, must be approved by the holder of the funds. Then under the purchase price, now we're moving along to paragraph B, which is the beginning of the corresponding paragraphs, or what we lovingly refer to as the legalese of some of the terms. So under the purchase price, so just paragraph 2, B2, it does state that they're just making a clarification for the public and for agents, and it just states that purchase price shall be paid in U.S. dollars. Method of delivery, again, acceptable to the closing attorney, including but not limited to wire transfer of immediately available funds. That had been there. They added the method of delivery in June of last year. But GAR this year added, for 2024, is adding where the agreement refers to sales price, it shall also mean the same thing as purchase price. So they're just making no bones about the fact that sale price and purchase price are used interchangeably in the contract. Now, moving along where it talks about keys and openers, GAR has added a little bit more items in there, and especially with respect to properties in HOAs where the owner has to turn in certain key cards or fobs or things like that back to the association when they leave. So what the verbiage now reads, or will read in 2024 under keys and openers, is at closing, the seller shall provide the buyer with all keys, door openers. Here's what they've added: fobs, access cards, codes, and other similar equipment to allow access to the property, community and community amenities. And then it goes on to say that in the event the seller is required to return the above items to a third party, for example, an association or management company, it states that the seller shall provide the buyer with the instructions as to how to contact that third party to retrieve those items. So again, that's just to further clarify at closing what has to get turned over. Now there is a brand new paragraph, B4C, and it's devices and fixtures. And what this is again, has to do with a lot of our smart homes have, the way they operate is there might be something physically attached to the property, but another device that operates that item, like these smart doorbells and security systems and things like that. So there is a whole brand new paragraph regarding this. It's called devices and fixtures. And it says, except as set forth above, and above is about the keys and openers, if a system, device, or fixture conveyed with the property cannot be operated without a specific controller, then not later than time of possession, seller will provide the buyer with all controllers which are required for the operation of the devices. Seller will also provide the buyer with all device credentials, including but not limited to usernames and passwords for all devices, including access and guest codes, or the seller may reset the devices to factory defaults and provide the buyer with all the default credentials for all devices. Seller will terminate seller's administrative access and any access granted to a third party. The cost of transferring third-party support to these devices and confirming that sellers and or third parties' administrative access is terminated is the responsibility of whom? You know, yes, the buyer. So again, that is a brand new paragraph that is just reflective of our changing times and changing technology with our smart homes. Now, moving on to the paragraph about the disbursement of earnest money. So once a holder is in possession of earnest money, how does a holder disperse earnest money? Well, there are many situations, and I can attest to this fact as a broker who has held earnest money. There are some complicated situations where a contract terminates and you really, really want to try to somehow divide that earnest money and give part of it to the seller and part of it to the buyer. However, that requires a judgment, not an interpretation of the contract, but an actual judgment. Who can make a judgment? Yes, a judge. So just so y'all know, the holder of the earnest money, this has always been the case, but for 2024, GAR has actually put this into words for clarification for agents as well as the public. The holder of earnest money may not split up those funds. So one paragraph that they have added to the disbursement of earnest money is it states that no interpretation shall be made by the holder dividing the earnest money between the buyer and the seller. So if a buyer and seller do choose between themselves to divide up the money, then they would simply execute the release portion of a TNR and direct the holder how to divide that up. But the holder cannot make that decision in and of within the interpretation duties that they are given. Now, moving on to the disclaimer paragraph. This is the paragraph that really protects agents and brokers and discloses to the public that we are licensed real estate agents and brokers, and we can only act within what our license allows us to do. So there is a huge disclaimer paragraph. It's paragraph B10C. And in this paragraph gets reworked a little bit every year for the protection of agents and brokers. But for 2024, the GAR Forms Committee has added the section that brokers shall have no duty to determine whether the identities of buyers and or sellers are legitimate. What does that mean? That means that in our world, especially this year, for whatever reason, there has been an inordinate amount of fraud, particularly seller fraud, where there is a fraudulent seller that is selling a property. And a lot of times it is not disclosed or discovered until right up to closing. And sometimes these properties close, and it's just a terrible, terrible issue. These bad guys are even getting fake driver's licenses. So GAR, in reflection of what has been going on, has just added that the broker does not have the duty to determine that. And then with respect to the new paragraph they added about devices and fixtures, under the disclaimer paragraph, GAR has added, buyer and seller further acknowledge that brokers have no duty to ensure that the seller has terminated the seller's and or any third party's administrative access to those devices that are left with the property. And again, that is in direct response or in addition to that brand new paragraph that they have added about devices and fixtures. Moving along. So in the assignment paragraph, where we have a lot of investors and wholesalers that are purchasing properties and do not have the intent of actually living in the property, but they are basically going to assign their position or sell their position in the contract to another buyer. And a lot of these investors or wholesalers, what they do is they will get a property under contract, and then they will go and advertise that property to solicit a buyer who's actually going to live in that property to take their place in the contract. But they can't list it because they're not the owner yet. They just have a contract on it. So GAR has spelled this out in the purchase and sale agreement for 2024 under the paragraph C4E, which talks about modification and assignment. And what they have added is this agreement may not be assigned or listed for sale in a multiple listing service by the buyer prior to closing, in other words, before the buyer actually owns the property, except with the written approval of the seller, and the seller may withhold that approval for any reason. Additionally, it goes on to say that any assignee shall fulfill the terms and conditions of the agreement. That had always been there. And for 2024, they've added, including but not limited to the obligation to pay any real estate commission owed by the assignor. So just while we are here, if you are working with an investor and writing an offer, and you know your investor or wholesaler is going to assign the contract, you need to get that seller's written permission. And so what you would do is you would use GAR Special Stipulation 611. And what that says is the seller consents to the buyer assigning this agreement to another buyer and having the assignee become the buyer thereunder. Now, you would have to add that the seller would also give the assignor permission to list the property in an MLS service. Whole completely different issue with our MLS services, but just wanted to let you know that is new in the contracts for 2024. All right. There is going to be a lot further explanation, and you will see all of these changes in context when you take one of our classes, but just wanted to give you a sneak peek and a preview of what to expect. All right, moving along, not a ton more, but we have a little bit more to go. So under the section about rules for interpreting this contract, and that is paragraph C4M. And basically what that is that just what like we all learned in pre-license school. And this used to be under the exhibit section and special stipulations section. They changed this last year, maybe 2 years ago, into a whole paragraph that handwritten changes control over pre-printed, exhibits control over the main body, and special stipulations control over exhibits and the main body of the agreement. We already know that has been in the contract in one form or another for a long time. Now, what they have added, they added last year, when in this section, they added that notwithstanding the above, any amendatory clause in an FHA or VA exhibit shall control over inconsistent or conflicting provisions in any special stipulation, another exhibit, or main body of the agreement. They further clarified that for 2024 by adding an additional subparagraph under rules for interpreting this agreement. And again, they still have that section about the amendatory clause of an FHA or VA exhibit. And it goes on to state for 2024, notwithstanding the above amendatory clause, notwithstanding the above, the amendatory clause in the FHA or VA exhibit shall control over inconsistent or conflicting provisions contained elsewhere in this agreement. Buyer and seller acknowledge and agree that the further agreement pertaining to the amendatory clause section in the FHA or VA exhibits does not conflict and is not inconsistent with the amendatory clause. What does all this mean? Basically, all of this means the amendatory clause, just to remind you, is in essence the appraisal contingency for a buyer getting an FHA insured loan or a VA insured loan. Meaning they have, if the property appraises by the FHA or the VA for less than reasonable value or the price that's stated, if you get a low appraisal and it's an FHA or VA loan, the buyer has the right to terminate the contract through day of closing, and their earnest money will be protected. Period. End of story. Now, these buyers can't just not show up to closing. They still have to send the termination notice, but they have protection for their earnest money upon terminating a contract through day of closing if they're getting an FHA or VA insured loan, if those appraisals come in low. And that is all contained and spelled out in the amendatory clause. What all of this is saying in the body of the purchase and sale agreement, and again, this has always been the case, they're just spelling it out for clarification and disclosure purposes, is you cannot write a special stipulation to avoid that. So these buyers getting these government insured loans have that protection for their earnest money, period, end of story, regardless of any special stipulation, regardless of anything else in the contract, and regardless of any exhibit. All right, now let's talk about just a couple more changes. Survival. The survival clause. GAR keeps adding things to this paragraph every year. They added a couple of things last year, and this year, under paragraph C40, survival of agreement, GAR has added 2 more additional items. One additional item, so now there are a total of 10 specific items that survive closing. Again, come take one of our classes to be familiar with all 10 of those with explanations. But the 2 things they have added is the section that refers to devices and fixtures, which is that new paragraph they have added. That section survives closing. And Another item that the Georgia Association of Realtors Forms Committee has added for the 2024 contracts is the seller's liability for not timely removing items from the property that the seller agreed to remove. So that survives the closing, that if the seller said they were going to remove something and they didn't remove it prior to closing, they still hold liability for the removal of those items. And under the closing, there are two brand new paragraphs. One defines closing, and one is more disclosures or warnings or caveats to help our public people avoid fraud. So why did they add a whole new section on closing? Well, you guys have all had experience where buyer and seller have gone to the closing table, signed all the documents, so forth and so on, but for whatever reason, it has not funded. Either there are some issues with the funding, or the closing occurred at the attorney's office late in the afternoon, or the source of the funding is in a different time zone. For whatever reason, documents have been signed, but it has not been funded. So the buyer and the seller get confused about, well, are we closed? Are we not closed? What about the exchange of keys? What about taking possession? So GAR has gone on to further disclose that and define that for our public with a brand new paragraph, C5F closing. And basically, well, not basically, what it says is the closing shall be the event in which the parties consummate the transaction set forth in this agreement. 1, the seller tendering the deed referenced herein to the property. 2, the buyer paying the required consideration hereunder. 3, both parties properly signing all documents and paperwork as required by the closing attorney. 4, both parties fulfilling other agreements set forth herein that must be fulfilled by closing unless they've been waived or amended to be done after closing. The closing shall be deemed consummated when the closing attorney confirms to the parties that the closing attorney is in receipt of all required paperwork, funds, and approvals necessary to complete the transaction, and directs for funds to be dispersed and documents to be recorded. So in real estate lingo, as agents, we know that means, and we've always known this, it's not closed until it is actually funded. So this is just spelled out in plain English for everybody, so everybody is on the same page. It goes on to say, this new paragraph, that all parties acknowledge that the deed will not normally be recorded in the land's records on the day of closing, and the payment of the sales proceeds may not always be made to the seller on the day of closing, even though the closing has been consummated, due to certain circumstances, such as, for example, the seller not being at closing in person, the closing occurring after the cutoff for wiring funds that day, or the terms of an escrow agreement signed by the seller have not been fulfilled, resulting in which portions of the seller's funds are being held back. So again, we've known this. This is not anything unusual. It's just spelled out to avoid any conflict or harsh feelings or confusion at the closing table. And then again, another new paragraph, again, to help us as agents and brokers prevent fraud and to protect us, is a new paragraph C7, and it's heightened identification procedures to help prevent fraud, covenant not to sue. There have been significant increase in criminals attempting to sell properties they do not own by posing as the owners of the properties. To help such crimes, sellers shall immediately, upon request of either the seller's broker and or the closing attorney, 1, provide the requesting party with information confirming the seller's identity, including a current government-issued photo identification. 2, meet in person or through audio-visual conferencing to confirm the seller's identity. And 3, if the seller is a legal entity, provide the request, that's like a business or an LLC, so forth and so on, trust. Provide the requesting party with the organizational and operating documents of such entity and current photo identification, and either meet in person or audio-visual meeting with the executor, manager, trustee, general partner, officer, administrator, and other person in comparable role of the legal entity to confirm their identity. Seller further agrees to cooperate with the closing attorney's heightened identification procedures, which shall at least meet the standards, if any, supplied by the title insurance company for whom the closing attorney is the agent. Seller acknowledges that the transaction may not be able to close unless such procedures are followed. In the event the seller breaches its obligations hereunder, the seller shall be in default of the agreement, and the buyer acknowledges that identity theft may occur regardless of the measures undertaken by the parties, their respective brokers and attorneys involved in the transaction to confirm the seller's identity. For and in consideration of $10 and other good and valuable consideration, receipts of $50, buyer covenants not to sue any brokers and or closing attorney involved in the transaction for damages arising out of or relating to a fraudulent seller. And that is it. The only other addition they made is under the list of exhibits. They had one line for other exhibits, and they have added 2 additional lines. So now we have 3 lines for others. So those are the changes to the purchase and sale agreement. Again, a lot of this will make more sense when you actually see the contract and see those changes in context. I look forward to seeing you guys in one of our classes. Stay tuned. I'm going to do an ongoing series on all of the changes, and we have 10 pages outlining all of the changes that the Georgia Association of Realtors is making to the 2024 GAR contract package that will be available on January 1st, 2024. Thank you all so much for watching. Please subscribe so you don't miss any of these video tips. And I am Dana Sparks, broker of Maximum One Greater Atlanta Realtors and director of the Real Estate Academy of America. Bye. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.